Thanks. Back for the pledge, please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome to the July 23 Planning Board meeting. I'll be sitting in for Neil Zuckerman tonight. We can have the roll call, please, Cheryl.
Joe Burden, Dennis Gagnon.
Here.
Peter Lewis.
Here.
Laura O'Connell. Here. Neil Toman.
Here.
Heidi Wendell and Neil Zuckerman.
All right, so we have a skeleton crew, but we do have a quorum. Approval of the minutes. Can I get a motion to approve the minutes from June?
I'll second.
All in favor? Aye. Okay. And with that, I also want to take a vote. We are not having a August meeting of the planning board, and I've been advised that we do need to vote on that. So I get a motion to that effect.
Who's that?
Second. All in favor? Aye. And I vote aye. Thank you. So we've got. Let's go down the list here. We've got a public hearing for Polhemus. We've got Garrison Café. Anybody here for Garrison Café? We've got Kozlowski and Effle, and then we've got Hudson Highlands Preserve. So, anybody? Okay, we'll get to the Garrison Café when we get there. So, our first up is a public hearing for Polhemus. You have to read the opening. Yeah.
The Planning Board of the Town of Philipstown, New York will hold a public hearing on Thursday, July 20th, 2023, starting at 7:30 p.m. at the Philipstown Town Hall, 238 Main Street, Cold Spring, New York, 10516, to consider the following application. Polhemus, Manitou Station Road, Garrison, New York, 10524, tax map number 89.1-4.2. Minor project, construction of a new single-family residence to be served by a proposed subsurface sewage treatment system and a drilled potable water well. Dated at Philipstown, New York, this 15th day of June, 2023. Neil Zuckerman, Chair.
Thank you, Cheryl. Jason, you want to tee this up for us? Yeah.
Jason Snyder with Beatty & Watson, representing the owner applicant, Polhemus Construction Management. We have a 2.5 acre parcel in the town's rural residential zoning district, Manitou Station Road. We are in the scenic protection overlay district, and we have a house in excess of 3,000 square foot footprint, which we both require planning board approval, which is why we're here tonight. So we do have the health department approval for the septic and well, and we have addressed a technical memo from the town's consulting engineer, which I believe is fairly complete. So we're just looking, we got a single family, four bedroom single family residence, 3248 square feet, and proposed septic and well. That's about it.
That's it. Now, did we have anybody sign up to speak?
I didn't check. But I just asked.
Is anybody here to comment on the application? All right. Going to entertain a motion to close the public hearing.
I'll make that motion.
Second. All in favor?
Aye.
Okay, public hearing's closed. Ron, next steps?
Yeah, the board has previously accomplished necessary referrals, as the applicant indicates. The Department of Health approval has been received. You had earlier classified the project as a Type 2 action pursuant to seeker, concluding your environmental responsibilities. So with the close of the public hearing, you may now consider whether you wish to have resolutions prepared for the next meeting.
Do we have any comments from the board on this? Anybody want to add anything? There was some, they are in a scenic overlay. There was some discussion about putting in some trees for screening or something, but there was nobody shows up at the public hearing, so I don't see, okay, nobody seems to think that is that important. So with that, can Can we get a resolution for Ron, what are you preparing? You're preparing a resolution,
For subdivision, or site plan approval.
site plan
Yeah.
approval?
Right, the seeker action had previously been taken.
We've taken care of that. So can I get a motion to get a resolution for a site plan approval first and second? Peter? Laura? Okay, all in favor? Thank you. I vote aye. And let's see, does that's it? We're done with them? Ron?
Excuse me? I'm
You're
sorry.
done, right? Okay, we're good. Yep. Thanks, Charlie. Sort of waiting, felt like somebody else was going to say something there. Garrison, anybody know anything about Garrison Cafe? Were they here? What do we,
Yeah, they're on tonight merely for the action of site plan approval. You previously had conducted a public hearing, you had made necessary referrals. The board at the last meeting directed me to prepare site plan approval reso, and that's in front of you tonight for consideration.
okay, so all we need is to
All
vote.
you need to do is vote.
All right, so can I get a motion to a vote, to approve the resolution for the application?
Yeah, I'll make that motion.
Second, Laura? All in favor? Aye. I vote aye. Thank you. Okay, moving right along here. Kozlowski, and help me out here. Effle? Effle? Okay.
So, based on the
Here we are.
based on the comments from the last meeting we had, the guest wing that was along the stream corridor has been completely eliminated. The driveway and the retaining wall there, which are existing, remain. Everything has been shifted. So the guest wing has been incorporated into the garage wing, and those additional disturbances have been, so we took the disturbance from along the stream and moved it over to the garage, and then not only that, but the garage got pushed out a little bit as well out of the buffer. So everything new, which was previously proposed in the garage wing, is outside of the buffer, as well as what was previously proposed is more outside the buffer. So everything else basically remains the same. We did get we had to push the proposed septic tanks out a little. I did go over the changes with Dylan from the health department, and he's good with, nothing with regard to the septic system has changed. It's the same fields, and we are eliminating the new well. We're going to be using the existing well, so that cuts down on some disturbance, trenching and clearing and whatnot. So, I mean, everything is outside of the buffer now, and away from the stream corridor.
Thank you, Jason. Any comments from the board members? No? Okay. Thank you, Jason, I appreciate you taking our requests, and we were looking at the plans. I mean, I'm okay with it. Anybody else have no more comments on it? Ron, the next step is to have you prepare a resolution.
Yeah, that's correct.
We've discussed the revised plans. Does anybody, I don't know, pardon me?
Oh, no, we were.
So, Ron, any other comments on where we should go with this?
No, you've accomplished all necessary referrals. You've previously classified the project as a type 2 action pursuant to seeker, so that environmental issue has been resolved. And it's now ready for consideration of the drafting of a resolution for the site plan approval.
Can I get a motion to that effect? Have Ron prepare a resolution for site plan approval. Dennis, Peter, all in favor? I vote aye. Thank you. Have at it. Yeah, thank you, Jason. Appreciate you doing that.
You're welcome.
Thank you. 12 minutes in. Look at this. 12 minutes. That's what I'm talking about. I know, I know. That's why I made the demarcation, so whatever we're, Hudson Highland Reserve, Mr. O'Rourke, I'm sure you're,
Yes, hi, good evening. Richard O'Rourke on behalf of the applicant. The program is for Hudson Highlands Reserve. As you know, we had the public hearing last time. It's been closed. We're moving along. There was a detailed submission that we provided to you in a timely fashion back on July 6th. And most recently, we had another letter from our proposed conservation easement holder, which has been distributed and which is in response to a letter that had been received by the planning board.
okay, so we've got a couple things. Are you ready? I'm sorry, are you done?
I'm done.
Okay, so we've got a couple things going on. We've got the introduction of the easement holder, and I'm going to let Ron and Aaron talk about this, but I'm just teeing this up for everybody else. We've got to talk about the, I guess, establishing the bona fides of the easement holder. We'll discuss that. Okay, well, there'll be that discussion, and then we have a few pages of issues that were asked and answered, for lack of a better term. So, Ron, you want to head into this? And I guess the idea here is that we're looking for an approval of the preliminary site plan so that you can move ahead with some of the, which you can't, you're stuck, you have things to get approved from the DOT and such, and you can't move forward with that until you get the preliminary site plan approval.
Yeah, that's correct. Preliminary subdivision approval. Right. And then with that, obviously, and Glenn can address this, we then obviously can move forward with the health department. As part of the submission, you saw that there's correspondence where conceptually, at this point, the county health department has no problems with what we're proposing. So, too, with DOT, we've had the preliminary discussions, but again, we have to have preliminary subdivision approval in place so that we can proceed down the path that we must. Obviously, with respect to the conservation easement itself, that is something that's typically the subject of final subdivision approval. The request,
As are the final revisions to the HOA, correct?
yes, that is
Okay.
correct, yeah. So,
Okay. Ron?
Okay,
Go Ron and Aaron.
the board recognizes the long environmental review that's been conducted on the project, resulting in a seeker finding statement being adopted last year. That subsequently allowed the town board to consider action on matters that they were seeking relief from, that the applicant was seeking relief from the town board. That included a rezoning of a portion of the frontage of the project from M to RR, which was accomplished. And they also obtained relief from the town road standards to permit them to use a 12% grade for the access road coming in from Route 9. The board has, again, since that time, conducted a public hearing on the preliminary subdivision application. That's been closed. Comments were transmitted to the applicant and responded to. We more recently have gone through a more detailed review of just the technical plans to provide the applicant's consultant with some guidance as to things to be resolved. But they're now at a point where the board can consider whether you want to have drafted a preliminary subdivision approval resolution for the project for the next meeting.
Aaron?
Sure, and just to add on to Ron's thoughts, we have I had a memo prepared in March, a few months ago, that just outlined the mitigation commitments that came out of the seeker process, and also the remaining approvals that are needed on the subdivision. If the board's comfortable, a lot of these items that we have asked the developer to provide to us, including the new draft HOA bylaws, which has a lot of that mitigation incorporated into it, addressing Ron's comments on the drawings. We could have the preliminary subdivision move forward and then work on getting these things prepared for the board and reviewed by the board and on Ron and I and Steve for a final subdivision approval. So I think sounds like the plan that has been discussed with Ron and Steve, and I'm fine with that.
Okay, Steve, you want to weigh in on anything here?
Yeah, there are two aspects to the conservation, three, I suppose, really, that need to be addressed in order to have the board vote for even preliminary approval. The first is the identification of a qualified conservation easement holder. The town code, particularly 175-21, says that the holder of the conservation easement has to be either the town board or a qualified not-for-profit conservation organization. The code does not go on to say what qualified means. Conservation organization is fairly straightforward, as is not-for-profit. So I looked a little bit into what possibly that could mean, and the best I can come up with is that the code refers to the environmental conservation law, particularly Chapter 49, as well as Section 247 of the General Municipal Law. The General Municipal Law citation is not helpful. It just says you can hold conservation easement. The environmental conservation law, however, and I'm not going to trouble you with the citation, says that a not-for-profit conservation organization means a not-for-profit corporation organized inter alia for the conservation and preservation of real property and which has the power to acquire interests in real property. Such organization must have qualified as exempt for federal tax purposes pursuant to Section 501c3 of the Internal Revenue Code or any similar successor statutory provision. So the requirements of the town code in regard to being a qualified not-for-profit conservation organization are minimal. If you meet the ECL's definition of not-for-profit conservation organization, in other words, you qualify as one, then you are a person who can take the conservation easement required by the conservation subdivision regulations. The documents submitted by the applicant and by the North American Land Trust indicate, and I think indicate pretty clearly, that the North American Land Trust meets that definition. So I think the board is in a position where you have to recognize North American Land Trust as a party that's acceptable, at least within the terms of the town code, to accept the conservation easement proposed for this subdivision.
They do appear to be qualified to hold the easement. Now, Steve, is that something that we have to vote on? And how do we formalize that? How do we formalize accepting the easement holder?
You would do that when you grant the preliminary subdivision approval. It will be part of, they've nominated a qualified not-for-profit conservation organization as the holder of the conservation easement.
Okay, so it's baked into the resolution.
It will be baked into the resolution. Right. I would add in regard to that the code provides that the conservation easement may be required to also be enforceable by the town board. And in this case, they voluntarily put in that the conservation easement will be enforceable by the town board in addition to the North American.
In addition to the primary easement holder.
Exactly right, exactly
Okay.
right. So I think that in terms of looking for their preliminary approval, they've checked that box.
All right.
Now, the other two issues were the conservation easement and the homeowner association rules and regulations, and how these two documents were going to be used to make sure that all of the measures that are being proposed to preserve the property are actually honored and carried out going forward. And there's two elements here. It's important to keep in mind that they're similar, but they're separate. One is all of the measures that pertain to the open space that's subject to the conservation easement. And the other is the measures that have been proposed in regard to the individual lots that are actually going to be owned by property owners. The first one deals with things like making sure there is an ATV trails or the like on the open space. And the second one deals with measures to make sure that people don't put down too much fertilizer or throw lawn clippings in the pond or cut down trees or the like. The conservation easement that's been provided, and this is going back to the DEIS, I guess, needs a little work. That's acknowledged by the applicant in the letter that they submitted. There's some technical things, like it still talks about the equestrian center and the like. But there are some provisions in it which, and I've talked with counsel for the applicant about this, need some minor changes. But on the whole, it's your standard conservation easement, and the terms of it should be sufficient to protect the open space that's proposed for this project. The declaration of covenants and restrictions and the homeowner association bylaws are, again, they're, well-written as far as it goes. They're pretty much standard form documents for these, for a homeowners association and a set of declaration of restrictions and covenants. But the set of the declaration of covenants and restrictions really only deals with the conservation easement. It doesn't pick up the restrictions and the requirements that were proposed in the finding statement and are going to be, I'm sure, required as part of the approval here. And the same could be said in regard to the bylaws of the, and regulations of the homeowners association. Again, it needs to be a little bit more detailed. It needs to spell out that there are certain restrictions that it's going to enforce in addition to the open space. But these are a paragraph or two that could easily be written into it between, now and final approval. I don't think that either the conservation easement or the homeowners association issues, and there are a few, are the type of thing that needs to hold up grant of preliminary subdivision approval.
Okay, so we have some revisions to make, but you're not seeing anything that's a deal breaker at this point?
Yeah, the board is going to have the final say over what goes into this as far as the provisions go. Grant of preliminary with a provision in it saying that, you need to have revised conservation easement and revised homeowners association documents in form acceptable to the board. I would not just leave it to the attorney for the board in this instance. Right. I think would be an appropriate condition to put into your preliminary subdivision approval. But again, I mean, unless, you feel differently, I don't think you need to see a revised draft before you grant preliminary.
Right, we have enough to go on here, and your feeling is that we're okay to move forward, I get it?
That is my advice, yes.
More details on what's the phrase, the things that run with the land.
Right, provided that you have conditions in the preliminary approval noting specifically that revised versions acceptable to the board have to be submitted before final will be granted.
Right. So I'm seeing that language is going to be all over this document, that there's going to be several times where we mention, I see hands going up, that's not what we're here to do. I'm hoping that no, I'm sorry, no, we can't. This is not a public hearing. But that's why I'm laying this out, is there will be opportunities for other conversations, and we've got a lot of revisions yet to make. And so what we're trying to do here is move them along with the preliminary subdivision approval. A lot of the reason we're doing this is so that they can answer the rest of our questions. No, I'm sorry.
We just have a copy of the letter that was submitted, apparently in reference to the one letter that was put in. There's nothing provided with the agenda. Apparently, there was a response by National North American Land Trust. All I'm saying is I think that needs to be provided. It wasn't back there, so we have no idea what the board has that we do not have.
If I may just make two comments. I know it's on the website. We received it and it was immediately forwarded to the planning board, and it's on the website with the agenda. That's number one. Number two, we have no objection to what's been discussed here. Obviously, we're at a point in time where now with preliminary subdivision approval, we are obviously committed to making all of the amendments that are necessary with regard to the homeowners association and with regard to the conservation easement. Those were part of the secret review. We're committed to it. I mean, there's no objection.
All right, and to be clear, the board would not be voting tonight to grant preliminary subdivision approval. All you're doing is directing Ron and Aaron to prepare resolutions that can be considered, I guess it would be at the September meeting, in regard to that. So
Right.
there'll be plenty of time for the public to take a look at everything that's had to date, and if you want to entertain, it wouldn't be a public hearing, but if you want to entertain comments before adopting the resolution, certainly it's some things within the board's prerogative.
So that's where we are. Are we okay with it? We're okay with this procedurally then? Everybody's on, and part of doing this is for me too, so, Aaron?
Yeah, I just wanted to point out, in addition to what Steve went through, which is very thorough, there's also a few things related to the construction of the subdivision itself, including like the building out the roads and the septic first before any homes are built. There's a SWIP requirement, right? They're going to be adhering to the tree clearing restrictions for Indiana bat. There's also a commitment to monitor Clove Creek during construction. So I think those three things, and there could be a couple others I'm not mentioning, it might make sense to have those actually part of the plat somehow. And Ron, we can work on that, how that gets put into the final. as far as-
Aaron and I have talked about this informally. I typically like to see all of those commitments on the site plan drawings because it's the easiest place to find that information. And that many people are not going to be looking through the written file, but they will look at the plats. So we'll try to evidence those as appropriate.
And that would be part of the conditional
Right.
final approval. So,
Right.
yeah.
Again, board members, anything before we,
Yeah,
Peter?
I had a couple of things. I understand that you need to have this approval before you can answer all these outstanding questions that, are that Aaron has placed before us. I do want to make note of the fact that we did receive a letter that asked, I thought, just a kind of a pertinent question. Did a little bit of, always a mistake, did a little internet searching and was curious as to why in the response to the letter that asked about the North American Land Trust not being accredited by the Land Trust Alliance. And then there was a response by the North American Land Trust saying, we didn't think that this was a good, we're not accredited because we think there were a couple of things that were improper for this particular accreditation. Is that something that you can easily summarize for us? Why they're not accredited?
What I can do is I can ask Mr. Carter, who's the president, to address that very issue. But, as we all know, and as he pointed out, 2/3 of the operational land trusts in the country choose to remain unaccredited.
Right.
And your code requires that there be a qualified conservation organization, not an accredited organization.
Oh, absolutely, and I understand from
And that's the code, so-
what Steve said,
Right,
that
right.
it's certainly organization that they could fit the bill. I was just curious why they felt that 450 other land trusts do think it's important. One of our own right here, the Hudson Highland Land Trust thinks it's important. I was curious why you didn't think it was, important.
Well, I'm certainly not an expert on that, and I can't answer that question, what's their particular basis. But, for example, as an attorney, and for 40 years, and having served as a judge for 27 years, I'm not a member of the trial section of the New York State Bar Association. I've had 42-day trials in New York State Supreme Court. But I'm not a member. That doesn't necessarily mean I'm not a good lawyer. And so, all I can suggest to you is that for whatever reasons they have professionally, and as I take it, there's others that feel the same way, they did not pursue that accreditation. That's
There
what-
are 800 other land trust organizations that are not accredited.
Right,
I
and
understand that.
there's no question that from everything we've done and we've looked at, this is a qualified organization, and it's a good one, so.
Anyone else? Thank you, Peter. No? Okay, so I think we're ready
There
to,
should be a motion to direct Ron to
motion to direct Ron to prepare
preliminary subdivision
Preliminary-
approval resolution.
subdivision for resolution.
Preliminary subdivision approval resolution.
Can I get a second? Can I get a motion to that effect?
I'll make it.
And second? You got a second? Okay, Peter, and all in favor? I vote aye.
Thank you very much.
Thank you, Richard. And let's see, what is it, right?
That's all we have to do.
That's it, we did the August, and so can I get a motion to adjourn?
Make that motion.
All in favor? Aye. I vote aye.